Hi friends, ladies and gentlemen. Today we are discussing a landmark judgment of our Supreme Court on sex work, the legality of sex work. The thing is that the sex work is no more an illegal activity and the police cannot harass the consenting adults. What I mean to say is that in a recent judgment in a case, considering the concerns of victims of trafficking for sexual exploitation, the Supreme Court held that this voluntary sex work is not an illegal activity and the police cannot harass the consenting adults. It is also observed that the consent of the persons, adult persons engaged in sex work must be considered primarily on decisions to rehabilitate, reintegrate or placement in shelter homes. The police cannot target the consenting adult persons or force them rehabilitation. The Supreme Court Division Bench, comprising of Justice J.B. Pardiwala and Justice R. Mahadevan, while analyzing the Immoral Traffic Prevention Act, observed that the provisions of a 70-year-old act do not empower the police to crack down adult persons engaged in voluntary sex work. The police should refrain from taking custody of persons who are engaged in sex work at their will. The court further observed that while renting of a brothel is an illegal activity, engaging in voluntary sex work is not an illegal activity. Since the women are engaged in sex work at their will, the question of rescue does not arise. Their rehabilitation must be voluntary. It shall not be coercive. So, the persons who are engaged in voluntary sex work shall not be coerced or forced to be rehabilitated. While accepting the submissions made by senior advocate Aparna Bhatt on the preparation of a victim protection plan, the court said that victims cannot be treated as passive objects of rescue and rehabilitation, but their individual choices and autonomy to be respected. The court's ruling emphasizing on consent and individual circumstances in the matters concerning rehabilitation and protective placements. Thank you.